All right, we're going to go ahead and get started here. I want to welcome everybody to our Export Controls and Economic Sanctions Enforcement panel. We've got a great lineup for you today. And so my name is Alan Insland. I'm a partner at Womble Bond Dickinson, where I lead our international trade and national security practice. That's part of a component of our global business team. And you're probably looking at your agenda and going, that's not Joe Whitley sitting up there. And you'd be right. So as many of you in the room, I'm sure know Joe. He had an urgent obligation that kept him from being here. So he sends a message that he's looking forward to seeing all of you at Chateau Elan, east of Atlanta, at the Southeastern White Collar Crime Conference in September. So with Joe's regrets. But again, very much glad to see a turnout. I don't think 5 years ago we would have paid to get this many people into an export control and economic sanctions presentation, but obviously anybody that heard Deputy Attorney General Monaco's remarks this morning knows that if it wasn't already front and center, then it needs to be on your agenda. So we have a great panel. Again, if you are a trade person, you're probably wondering how we have this many great Americans on this one panel. It's rare to get everybody's schedules to sync, so a huge opportunity. So be thinking of some good questions to hit the panel with. But wanted to also, I will say that in the interest of time, obviously everybody's bio is extensive here. So the bios are in your materials. So I would encourage you to look at the materials for the full bios, but I'm really just going to do a quick introduction. So to my immediate left is Matt Axelrod. Matt is the Assistant Secretary for Export Enforcement at the Bureau of Industry and Security at Commerce. And then to Matt's left is Steve Francis. Steve is the Acting Director of Homeland Security Investigations at DHS. And then to Steve's left is Andrea Gacke, who is the Director of the Office of Foreign Assets Control, OFAC, at Treasury. And then last but not least is Matt Olson, who is the Assistant Attorney General for National Security, running the National Security Division at Justice. So we appreciate all of you taking the time, to be here. And one of the things that I think it's important to do, I know we have probably a lot of variation of background in the audience, and so we want to keep this have something for everybody here and to cover a lot of ground. But for any of you that don't face trade issues on a daily basis, or if it's been a while, there are a couple of points that I'd like to throw out just at the beginning, and these are themes that you're going to hear probably repeating from our panelists. But just to put things in context is that right now, the U.S. government is in a bit of a methodology change as to how trade controls are applied. In particular, I would say that it's most easily envisioned through export controls, whereas we're moving more from a Cold War non-proliferation type of system to something that is a bit more nimble and a bit more asymmetric, and gives all the fine Americans to my left more tools to be able to combat threats to our critical technologies, to our critical infrastructure, safeguarding sensitive personal data and things like that. One comment that I wanted to throw out kind of as a set piece, I heard it at a BIS conference several years ago where it was summed up that we're going to increasingly start controlling what they can make versus what they can buy, with they being our, national adversaries and their instrumentalities. And so if you think about that, it is a bit of a sea change as to how that system has to progress. And you see it not just in export controls and in the sanctions side. Probably when I said that a few minutes ago, if any CFIUS ears in the audience went up when I used the critical technology, critical infrastructure, and sensitive personal data, that makes the second point, which is you cannot look at any of these areas in isolation, and you certainly can't from the enforcement side. If there's no other theme than you're going to hear today, it is that everybody works together. It is a whole of government approach, and it's getting more so that way. So your compliance has to obviously, tailor to that as well. So with that as background, I want to just start, and Matt, And the other thing is we got two Matts, so we're going to have to use last names unless they have nicknames that we're unaware of. So, what is it about the national security environment and the global issues today that really make it important for us to focus on export controls and economic sanctions?
Yeah, thanks, Alan. Thanks, everyone, for being here. Let me start this way. So the Director of National Intelligence every year puts out a global threat assessment that goes through the greatest national security challenges and threats facing our country. The first year that there was such an assessment was 2006. ODNI got stood up in the wake of 9/11. In that report, not surprisingly, number one national security threat to the U.S., you can all probably guess, it was the threat of terrorism from non-state actors like Al-Qaeda. The most current global threat assessment from ODNI, which was last year's, I think this year's is due to come out shortly, that's not the number one threat they list anymore facing us, our number one national security challenge. It's instead the threat from state actors, China, Russia, Iran, North Korea. And part of that threat and part of that challenge comes from the fact that state actors are trying to catch up and eventually overtake us militarily in order to try and shift the balance of power in the world. And one of the ways they're doing that is by trying to take advantage of rapid advances in technology. And so the work that we all do collectively, and that we do at the Bureau of Industry and Security at Commerce, is really designed to make sure that we're keeping our country's most sensitive technology out of the world's most dangerous hands. And I think there's a growing recognition in U.S. policy community all the way up at least as high as the National Security Advisor, Jake Sullivan, who was recently talking, I think it was September, about how preserving America's technology and science advantage is a national security priority. We no longer need to just maintain a relative advantage compared to some of our competitor countries. We need to maintain as large a lead as possible when it comes to key sensitive technologies. And so, like I said, I think there's this growing recognition that this is a critical challenge of our time, and the tools that we collectively have to bring to that challenge, I think, are very powerful. And just speaking briefly for us, I oversee a team of agents and analysts that enforce the country's export laws. We do that in partnership with the people on this stage. When we go criminal, we often work with HSI, with FBI, with others, and Matt Olson's prosecutors, along with AUSAs around the country, prosecute our cases. And then we also have a suite of administrative enforcement options, including charging letters we bring internally with Department of Commerce lawyers, as well as being able to place people onto the entity list or issue denial orders. It's all a part of, I think, what the Deputy Attorney General mentioned this morning, which is the growing intersection between national security and corporate enforcement.
Okay, thanks, Matt. Andrea, you want to tell us kind of from OFAC's perspective?
Absolutely. Thanks for the opportunity. First, I want to just thank everybody for showing up, but also for my inclusion in this esteemed panel. I think it's the first time that OFAC's ever spoken at this conference, and it's quite a great opportunity. So from my perspective, OFAC is a pretty small office within the U.S. government, but it does pack an outsized punch, in part because we leverage our relationships across the U.S. government. Where OFAC figures in is we implement and enforce economic sanctions on behalf of the U.S. government. And what that means is that we are, when the president declares a national emergency, we are crafting the prohibitions and applying sanctions, blocking people's assets, prohibiting certain export of services to certain parts of the world. And from there, that sets the framework on which civil and criminal enforcement takes place. But in the past year, we've been presented with a challenge and an opportunity that I've never experienced in my time working in sanctions, and that was Russia's further incursion and invasion of Ukraine. What we saw was a coalition of the G7, the group of 7 countries, coming together and simultaneously crafting and applying economic sanctions at a time that, at a pace and with with an ambition that I'd never before seen equaled in the world of sanctions. So what that means in terms of why sanctions are so important, they are often the first tool out of the toolbox when dealing with a national security threat. They're frequently, to Matt's point, being used against complex actors in economies with real repercussions. And it is our challenge to craft those sanctions in a way that trains the effect at the target and minimizes unintended consequences, but also to explain the consequences so they can be effectively implemented, and so that, multinational companies know exactly what the expectations are, what the rules are, and know how to avoid the diversion and evasion that we see happening every day when it comes to sanctions.
Okay. Thanks, Andrea. So Matt Olsen, could you talk a little bit about, I know there's quite a few things that were covered this morning from Deputy Attorney General Monaco that I know that you're going to get to a little bit later and talking about some new changes, but the increasing relevance of export controls and economic sanctions to the DOJ's National Security Division. Can you comment on that?
Yeah, sure, and thanks, Alan. Thanks, everybody, for being here. And maybe I'll pick up on your point, Matt, about sort of the evolution of the threat, because the National Security Division at the Justice Department, which I lead, was started in 2006. And like the DNI and the Department of Homeland Security, these were major government transformations in the wake of 9/11, given the nature of the threats we face from terrorism. But if you go fast forward to, as you said, Matt, to the current threat environment, yes, we're still focused on terrorism, we're still focused on Al-Qaeda and ISIS and other non-state groups. We are increasingly focused, and really paramount focus is on nation-state actors, those countries that you listed, Matt: Iran, North Korea, Russia, and particularly China, and the threats that they pose to us in a number of ways, right? Not just from the perspective of espionage, which we handle in the Justice Department, but economic competitiveness and really protecting our competitive advantage when it comes to sensitive technologies. So the Justice Department, as everybody knows here, is where in some cases the rubber hits the road, because we are responsible for criminal prosecution, and increasingly we're seeing that tool in coordination with partners at Treasury and Homeland Security and at Commerce. The ability to prosecute under our criminal laws is the most powerful and effective way that we have in many cases to enforce the laws that affect our national security. So as you mentioned, one of the things that we're doing is really trying to highlight the intersection between national security and the enforcement against corporate actors, and learning from other areas of corporate enforcement how we can ensure that when corporate actors are taking steps that implicate national security, that we're bringing our best learning to bear. And that means understanding that corporations are on the front lines, often seeing these types of violations in the first instance, and working with corporations, but also being willing to bring the full weight of the criminal law to bear when there are violations. A little bit more specifically, I'll just mention a couple of sort of specific efforts that we have. Klepto Capture is a task force that we've set up, as you mentioned, Andrea, in the wake of Russia's invasion of Ukraine, to bring costs to the Kremlin for its invasion. I got a quote this morning from The Guardian, which ran an article about the work of the sanctions regime, and it's a well-known Russian oligarch, Oleg Deripaska, said that the Russian government funds are running low and the country is facing serious pressure due to Western sanctions. So we know these are working. So there's more work to do, but we're learning from both the general way we've gone after corporations that commit wrongdoing, but also in particular we're learning in the export control context from the work of Task Force Klepto Capture and the sanctions work we've done over the past year.
Okay, great. Thanks, Matt. So Steve, can you talk a little bit about Homeland Security investigations' role in addressing some of these emerging threats?
Sure. So it's great to be here as well. Thank you, Alan. Thank you, everyone, for being here. Because of the national security threat that China, Russia, North Korea, Iran pose to the United States, from a law enforcement perspective, I think it's very important that we, across the U.S. government, leverage all of our investigative authorities from disruptions to investigative capabilities across the interagencies to ensure that we're enforcing export violations, sanctions evasions. And I think it's a really, when I look at Homeland Security investigations and kind of leading the organization today, there's very broad jurisdiction that we can bring to the table, from enforcing Title 8, Title 18, Title 19, Title 50. As a border agency that has a global reach, there's a lot of things that we can bring to the table, and we can't do it without, of course, the private sector and our interagency partners. So with this threatening landscape, it's important that we continue to do that. I think in 2010, when President Obama issued an executive order to establish the Export Enforcement Coordination Center, the E2C2. It's led by Homeland Security Investigations, but every one of our partners, 24 different agencies that sit there, that coordinate with one another, deconflict, and ensure that we're utilizing and working together to enforce these, the changing landscape in this environment.
Okay, great, thank you. So now we're going to transition, kind of going from a little bit more general to a little bit more specific, and talk about the different ways that you're each going about addressing this threat landscape, in particular talking about some priorities, initiatives, particularly with a mindset toward this year and maybe into the near future. And Andrea, would like to start with you.
Absolutely. So I think you'll hear from all of us, the priority will remain Russia, Ukraine. Specifically, last week marked the 1 year, was the 1 year mark of Russia's invasion of further invasion of Ukraine. OFAC took a number of actions. I think we listed over 100 individuals and entities focused on sectors like wealth management, the financial sector, but also actors that were facilitating transactions for Russia to strengthen its position on the battlefield. And that will remain a focus for us, certainly, and I think across here. We are looking to degrade Russia's ability to prosecute this war. And we know that sanctions are having an effect, to Matt's point. We know that that Russia has tasked its intel agencies, the FSB and the GRU, to find ways to evade our sanctions. So this will remain a continuing priority for, I think, all of us on this panel, and other folks who are not on this panel. Other priorities for OFAC in particular is we are very much focused on anti-corruption efforts, using sanctions to focus on that. Also, focusing sanctions guidance on the digital assets space. This has been a lot of emerging trends there, and those I think I'll conclude with our top areas of focus.
Okay, and I will say this, just as it strikes me, practicing in the sanctions area, that first off, most people don't realize that your office administers, I believe, last time I looked, 38 separate programs.
That's right, about 40. Yeah, yeah.
So, and then, the amount of assets that I'm sure you had to roll in onto the Russia to continue to address the Russia issues and everything like that. But it is noted that, OFAC hasn't taken its eye off the other balls as well, because we see the designations and actions taken with regard to the other programs. So. That's
right. I think earlier today, just this past week, we issued sanctions actions on North Korea, 2 focused on CJ&G for arms trafficking and timeshare fraud, not narco trafficking actions. We also we executed a pretty large action today that we worked with the State Department, focused on Iran's illegal export, or its exports of petroleum.
Okay, great, thanks. So, Steve, how about upcoming priorities and initiatives from Homeland?
Yeah, so I'm biased, right? I started my career at U.S. Customs Service conducting export investigations, sanctions. So now when we set our goals and priorities, fortunately for us, about a few years ago, we took a look at export enforcement and then are really looking at it that was under our National Security Division and moved it under our Global Trade Investigations Division. So we realigned our priorities under a trade portfolio, and I became the assistant director of our Global Trade Investigations Division, and we're looking at all things, the illegal exportations, munitions, dual-use technologies, but also the counterfeits and illegal importation of goods, protecting national security and the economic security of the United States. So it's really played a great value for us to look at things for all things trade, illegal importation, and exportation. And then when we're looking at our investigative priorities, of course, the sanctions and embargoes traditionally, in the last 2 or 3 years, a lot of Iranian tanker investigations that resulted in almost $200 million worth of seized assets, looking at the financial flows, working those cases very jointly among the interagencies with FBI and OEE. Also, as we were able, fortunately, to pivot towards Russian sanctions, international sanctions, and leveraging our international portfolio. So we've been quite successful working with the Department of Justice on the Klepto Capture Task Force. And as it relates to Venezuela, the FCPA, a lot of great work that's happening out of here in Miami, out of our HSI Miami office, working with our interagency partners, seizing a lot of assets. But as we're looking at the future with international and prioritizing, we're looking at the emerging threats and transshipment points as well. So we're doubling our kind of resources and engagement overseas, working in Hong Kong, Taiwan, Germany, Malaysia, Singapore. These are the countries that we're seeing through our investigative results that we need to focus on those transshipment points and leveraging our customs authority, working with our partners overseas.
Okay, thanks, Steve. Matt Olson, we got a bit of a foundation laying this morning, talking about some exciting new initiatives coming up at Justice. What can you tell us about?
Sure. As we look ahead to this year, I think taking a bit of a step back, one of our biggest priorities is literally the topic of today's conversation, and that is enhancing, increasing, and being aggressive in enforcing sanctions and export control violations. What we've talked about and what I've mentioned is because of this increasingly complicated and dynamic geopolitical landscape, there are significant risks for companies who operate globally. And we want to make sure that we are enforcing the laws against companies when they violate the criminal law. And an example of one such prosecution that got some news was just a few months ago, a company called Lafarge, a multinational construction company. We had evidence that the company's executives were funneling money to ISIS in order to continue to operate in Syria. The company pled guilty and was sentenced to pay a financial penalty of over $750 million. So as we look to how we're going to prioritize, whether it's that type of a case or our sanctions and export control cases, it's really a reflection of the nature of the threats we face given the overall landscape. But so two particular areas, and I mentioned one of them, is in the sanctions area. It's hard to believe that OFAC hasn't been represented in this forum before because we work so closely with OFAC on sanctions and sanctions enforcement. So the Klepto Capture Task Force that I mentioned and its success in really imposing significant costs on Moscow for the invasion of Ukraine. But the other, and I know we're going to talk more about this, is the new strike force, the disruptive technology strike force that we've stood up along with Commerce, which is an effort to really protect our most sensitive technologies. So those are two major efforts. Underneath that, let me just, if I may, talk a little bit about some structural changes within the National Security Division. We're going to add a significant number of people to our counter-espionage and export control section, the CES. We recently had the departure of somebody who's here today, Adam Hickey, who led and built much of that program. So we decided we lost Adam Hickey, we need to add 25 people to compensate for losing Adam. But in all seriousness, as I say that and as I look out, if there are those of you or you work with folks who are interested in returning to the best job you ever had when you were in government, there's going to be opportunities for folks to come in and work in the government on these incredibly important cases. We're also revising our voluntary disclosure policy. We are adding an individual. We just posted an announcement for a chief counsel for corporate enforcement. So we're doing a number of things that we can do just structurally to enhance our capacity to go after corporate wrongdoers and to be better at enforcing sanctions and export control violations because they so often implicate significant national security issues for our country.
Okay, great, thanks. Switching to the other Matt, how about new priorities and initiatives at OEE?
Sure. Yeah, like Andrea said, obviously, when we're talking about countries, we're going to continue to focus on the work in Russia and China, Iran, North Korea, and it's sort of a matrix approach is how I think about it. It's right, things going to those places that are sort of the most sensitive technologies are kind of top of our list from an enforcement perspective. But let me hit like three sort of things that I'm thinking about for this coming year. The first ties to what Matt Olson said, which is good since he's the one who prosecutes our cases. We want to bring more corporate enforcement actions, obviously when the facts and law warrant. But I am a firm believer that we need companies to invest in compliance, to think about their risk from export and sanctions violations the way that they think about and that all of you have gotten them to think about their risk from FCPA violations. In other words, we want them to know that this is an important area. It is important to resource. We would much rather work with companies to help them prevent violations on the front end than enforce on the back end, because when you're enforcing on the back end, that national security harm has already happened. But sometimes, as I'm sure you all know, to get companies to really focus on the front-end prevention, there has to be a couple of examples of back-end consequences in order to get people's attention. And so I imagine this year you might see some of that. The second thing I would say is we've put a real priority last year, and we'll continue to do so this year, on partnerships. I know we're going to talk about the interagency partnerships in a while, and maybe we'll get to international partnerships a little later too, so I won't hit those here. I'll just hit our partnerships with academia and with industry. We're a little different than some other federal law enforcement agencies. Look, we're the Department of Commerce. We work really closely with business, with companies, with universities to work in sort of a partnership, more of a partnership model and an educational model. Our regulations can be complicated. We have agents responsible for every geographic area in this country. We don't have agents located in every area, but we definitely have agents responsible for that part of the country, no matter where you are. And if your clients or you don't know who your local Office of Export Enforcement or OEE agent is, I encourage you to get to know them. They're an incredible source of knowledge and can give advice when you have questions. And then also, if there's ever a problem or an issue, you can call them and talk with them about how to navigate it. On the academic side, we're doing an academic outreach initiative where we've assigned specific agents to specific universities who are, willing to participate with us. We don't just impose it on them, but to give them some sort of enhanced trainings about what to watch out for and how to protect their research from foreign adversaries. The third thing I'd mention is some policy stuff. So we did a lot of policy changes last year, which you may be aware of. I think I may have talked about some of them at this conference last year on our administrative enforcement side. One of the changes we made was with how we process voluntary self-disclosures. We're going to continue looking at voluntary self-disclosures. As you heard from the Deputy Attorney General, as you heard from Matt, there's a lot of sort of change and thinking and evolution of how voluntary self-disclosures work at the Department of Justice. We're going to make sure that what we're doing is sort of in line and complementary to what they're doing. So nothing to announce today, but maybe down the road this year we'll have some more to say there.
Okay, thanks, Matt. So we're going to transition now to talk a little bit more specifically about the interagency coordination. We've heard reference to this subject from all of you really already, but want to continue drilling down a little bit more specific. Matt Olson, you mentioned a couple of times about the Klepto Capture Task Force. Could you delve a little bit more into exactly how that task force works with, in terms of, safeguarding against sanctions and export violations?
Sure, and this was, as I mentioned, the Task Force Klepto Capture was stood up in the immediate aftermath of Russia's invasion of Ukraine a year ago, and it's had some remarkable successes. The idea was really to focus on those oligarchs that were facing sanctions, and also to work with OFAC and the State Department to impose sanctions where appropriate, and then to enforce those sanctions through our criminal and civil tools. And As I mentioned, we've seen the success as noted by one significant oligarch recently today in the paper, but there's also been seizures of yachts owned by oligarchs, seizures of bank accounts, security accounts, and this is obviously part of an all-of-government effort, which includes all the Defense Department, the State Department, to impose significant costs on the Kremlin for its invasion of Ukraine. But this works only because of the partnerships that we have, and those partnerships include folks here on the stage as well as at the FBI and across government. And that's, I think, as we look forward a little bit, I think we're going to be increasingly focused on cracking down on money laundering and sanctions, evasion, and those who facilitate that, right? So there's the oligarchs themselves, but then there are others who are involved in the propping up the oligarchs and facilitating them. They're sort of the gatekeepers. And so we found these tools to be very effective, and we're just going to be, we've learned a lot over the past year and how quickly we can move when we put our mind to it. And this task force, KleptoCapture, really was a sort of a case study on how to do this effectively. And required a lot of work from a lot of folks, but really it was centered in the Justice Department with prosecutors who were assigned to the task force to carry it out.
Okay, thank you. And then talking about another interagency initiative that has been mentioned here already is the Disruptive Technology Strike Force, if I've got it correct, which I think was announced like a couple of weeks ago, or 16 February, I believe, is when it came out. And I know that it's a blessing for this audience that you're talking to some of the main architects, I believe, of that policy here. But what is that designed to achieve? And also I'd ask you to try to address what's a bit different about maybe even the scope of who all is going to be participating in the Disruptive Technology Strike Force.
Well, and I'm going to, I'll speak for a moment, but I'm also going to defer to Matt Axelrod. And I appreciate you getting the acronym right. We thought we'd have a task force over here and a strike force over there to avoid any confusion. But look, I do think we learned from what we did with KleptoCapture the past year. When you focus attention and resources on a problem, and you do so in partnership with the investigators and others who have authorities to bring to bear, you can make a big difference. And so the goal with our disruptive technologies is to prevent the flow of sensitive technologies to our adversaries. And those types of technologies include, quantum computing, semiconductor, other powerful computing technologies, bioscience, all the things that keep the United States in a competitive advantage with our adversaries. So the goal, and just structurally, is to, we have the statutes and we have the authorities on the books, so how do we marshal our resources? And the goal is to create cells in the key areas, regions where we can bring prosecutors together with investigators from Commerce, Homeland Security, and the FBI to really focus our efforts in those regions where we think there's the most likely that we're going to be able to bring cases. So it's brand new. But it is, I think there's a lot of excitement within the U.S. attorney community, and I know there's a lot of support at the highest levels of the Justice Department to make this work.
Mm-hmm. Matt, do you have anything you want to add to that?
Sure. So on the strike force, we actually had the very first sort of meeting of a strike force cell yesterday here in Miami with the U.S. Attorney, and the U.S. Attorney's Office hosted it, and we had Matt and the NSD team were there, and I was there, and we had HSI folks present, as well as FBI, and someone from DCIS came too. So when we rolled out the strike force, DCIS, we hadn't sort of talked with them yet about it, but there's a lot of interest in participating, and it's really the more the merrier, because it's a sort of team effort. And Matt outlined how the strike force is going to work. I'll hit, if I can, a couple other interagency things, because I think one of the most of the panels you're at this week, my guess is that the panelists, they got to meet each other maybe the half hour before the panel. That's not true here. Like, we know each other really well because we're on the phone with each other all the time, because we work together all the time. I'll give you a couple of examples. OFAC, Andrea and I, right, we're doing a lot together. I think, watch this space, but I would not be surprised if sort of down the road you even saw some joint resolutions coming from our agencies. Just today, there was a joint compliance alert for the first time ever from OFAC and DOJ and Commerce, which was telling companies about red flags to watch out for when it comes to third-party evasion and transshipment for the Russia controls. So we do that kind of work together. We also work with FinCEN, which is another component at Treasury Department in the same sort of bureau where Andrea works. We did a joint alert with them earlier, I guess it was last year, and a specialized SAR code for financial institutions to use if they saw transactions that might be related to evasion of the Russia controls. Our analysts are now able to pull down the SARs that have that specialized SAR codes and use those SARs to predicate investigations and entity listings, and it's been hugely helpful for us. The other thing I'd hit quickly is it's just, I think, a really good example within the past week, 3 cases, all of which show how when it comes to enforcement, we work together. So today, in Kansas City, there were the arrests of 2 U.S. nationals who were arrested for sending U.S. aviation technology to Russia. That's a case that FBI and Commerce are doing, and DOJ, of course, are the prosecutors. We had a case from Friday out of EDNY where it was spectrum analyzers and signal generators that were being procured. Essentially, this guy was acting like an FSB procurement agent and then coming over to the U.S. and getting the items and then bringing them back to Russia and then on some of them to North Korea. That one was HSI and FBI and us and CBP. And then, of course, EDNY were the AUSAs, and then Matt's prosecutors from CES. So talk about a lot of folks coming together to make a great case. And I'll just highlight one more that was from Monday. We did a administrative action. It was a resolution. We had one resolution. The State Department had a resolution, and DOJ had a civil resolution, all against the same company, 3D Systems, which was sending aerospace and military electronics blueprints over to China. They're a 3D printing company, and unbeknownst to their US-based customers, they weren't 3D printing their items here. They were sending the blueprints to China to get them 3D printed there. But of course, when the blueprints go to China, those blueprints are controlled, and if you send them without a license, that's a violation for us. And when it was ITAR violations, that was a violation for the State Department. So I just highlight those 3 actions. That's just this past week, but none of those 3 actions is one agency alone. They're all had a minimum of 3 agencies working together, and that's what we do sort of every day, because that's how we are able to attack these problems in the most effective way possible.
Okay, great. Those are great and timely examples. And so continuing with our theme again of interagency coordination, Matt, you just covered a lot from the export side. I want to also give Andrea and Steve a chance to talk about, in particularly for all of you, it's clear that you all work together, but one of the questions that always comes up too is, how do you make sure that you have continuity of effort, that you maximize your effectiveness, but you don't duplicate efforts or create confusion for the compliance public?
Yeah, and I just want to echo, I think what both Matt said is that, we are coordinating and working across our agencies all the time, and in regular conversation, not just at our levels, but our staff are very, very close. And if I can pick up on the KleptoCapture example, I think, from the early days, we were very tightly joined with the prosecutors working on KleptoCapture, because what we bring to the table is we can freeze the assets, but that's all we can do, is freeze them. We need Matt and his prosecutors to actually seize them. So we have been working so closely and leveraging that internationally in a task force that brings together other countries. We call it the REPO Task Force, the Russian Elite Proxy and Oligarchs Task Force, which is just trying to replicate, KleptoCapture at an international scale. And so, but yeah, it is essential for us. We need to work with everybody for our actions to be effective.
Yeah, look, when I see interagency cooperation, I mean, this is how I define success in our organization. We want to make sure we're working with our partners, and it's really, when we look at the commerce agents, FBI agents, working with OFAC, and the leadership really at DOJ with the Klepto Capture Task Force that kicked off, I think that really brought everybody together. The work has always been done in somewhat of an informal way, formal, but the Klepto Capture Task Force has really highlighted our capabilities. And also, I'm really excited about the Strike Force. When Matt reached out to me about this idea of the disruptive technology Strike Force, I was ecstatic because, for decades now, and I've worked in this space, a lot of that work happens, in good offices, relationships that are being built. But when we have leadership at the highest levels across Department of Commerce, OFAC, DHS, Department of Justice, all focused on an area, we're going to be quite successful utilizing all of our different authorities and jurisdictions and our global reach. So just when we talk about interagency cooperation, that excites me about where we're going to go.
Mm-hmm. That's great. We want to turn now from interagency coordination to international coordination. And we know that there have been some opportunities for that, at least over the past year. And so, could each of you talk about how your agency, reaches out and has that international component, to its agenda? And Steve, we can start with you on that.
Sure. We have about 270 agents located in 93 countries around the world. We're expanding our international portfolio. Most of the work that we're looking is really on customs trade authorities that we can work with our partners that have similar or authorities to enforce trade violations. And I think this export enforcement, sanctions evasion falls right into where we think we can continue to build a lot of capacity building. We do a lot of training, State Department funded programs through export control and border security. We have also invested in the future of our agents in those relationships. Our customs mutual assistance agreements, legal binding authorities that we share customs information with from investigators both in the US and overseas. And then we also have started, and I think we're at close to 15 different countries on bilateral trade agreements where trade information is being shared with HSI and customs authorities overseas that are focused on anomalies, trade data that maybe, where our intelligence kind of capabilities can expand in that area. So there's a lot of information that's being shared. And this is where I think, it's going to be open to the interagencies on the strike forces. It's going to be continued to shared on the Klepto Capture Task Forces. So our international portfolio is expanding, and it's nice because it's been built on decades of trust. So there's a lot of law enforcement reach there.
Mm-hmm. Okay, thanks, Steve. Yeah. Matt Olson, for DOJ and its international partnerships and affiliations.
Sure. I mean, it just by definition, right? We're talking about sanctions and export control enforcement. These matters cross boundaries, right? They cross international boundaries, and what we're talking about the movement of goods and assets and from overseas, from the United States, and so it's imperative for us to have good relationships with our law enforcement and prosecutorial partners. We have great relationships, obviously, with our Five Eyes partners, and we've worked closely with the UK and with European partners to share evidence, to share intelligence, and to share best practices. And I think that's one of the things I saw most recently with the Klepto Capture was, and with the Repo Task Force, was really what are we doing here? And often we're leading. To be honest, the United States is leading in this space, but we're doing so with our arms linked with our partners around the world, and that's what's led us to, for example, to be able to seize the yacht worth $300 million, a 348-foot yacht that belonged to a Russian oligarch, where we did that with the close cooperation of law enforcement officials in Fiji. So it's just absolutely essential, and we've learned again from the counterterrorism example, right? We've built these relationships over decades. And if I could say one other thing, I think you made the really great point, Matt, about the general way in which we approach partnerships within the United States as well. And I think one of the things a lesson for me as we take on these priorities, and I think this is probably something that would resonate with folks here, especially if you've worked in government, is you don't necessarily need a lot more people or a lot more money to change their priorities. And what you need is the demand signal from headquarters. And that can just make a huge difference. And I think in a lot of ways when we talk about the klepto capture team or our new disruptive technology strike force, we are changing the demand signal from headquarters on the importance of these as a priority. And that ripples out to the places where the real work happens, whether it's a U.S. Attorney's Office, which is on the front lines of bringing cases, or field offices of our investigative partners. And once they get that demand signal, they know these cases matter, they rise to the occasion, and with our support from headquarters. And I think that's a lesson that crosses over from one context to another, and I think we just know how it works, and we're going to apply it now in the export space.
Okay. Thanks, Matt. Andrea, I think it goes without saying that oftentimes our sanctions programs are not the most popular with our international, even with our allies, but in this last year, there's obviously been an unprecedented opportunity for international cooperation. Could you talk a little bit about that from OFAC's perspective?
Absolutely. The time was that a lot of our sanctions programs actually created friction with our closest friends. For example, even at the height of our Iran sanctions, we were going throughout Europe urging them to do more and not getting a lot of purchase there. That's changed when, with the crisis in Ukraine, and now the UK government has had a sanctions office within its Treasury Department called OFSI, the Office of Financial Sanctions Implementation. They're radically scaling up to almost, approximating the size of OFAC. And we have announced a joint partnership that we'd never had before, which basically where we are regularly consulting each other on licensing practices and policies, on enforcement policies and practices. Up until recently, they had no civil enforcement authority in the UK. They had a prosecution or a strongly worded letter, and now they have a civil enforcement authority, that they're trying to create, and we're talking them through our experience of crafting our civil enforcement regime. And now the EU is coming online. They are developing to the extent they can. It's a much different system. I will not bore you with the details. I know you all know this without telling me how they can actually have a centralized sanctions body within the EU. It's going to be tough. We'll be working with them. I know that Matt and I have talked about the difficulties there with the different kind of siloed ways they approach this, but we're going to work with them very closely to see if we can actually improve the implementation and enforcement across jurisdictions of our sanctions.
Okay, great. Thanks, Andrea. So, Matt, what about international cooperation from export enforcement standpoint?
Yeah, it's thanks, Alan. It's really key. I mean, as you know, as a practitioner in this area, export controls are really only effective if they're multilateral, and by that I mean if the people who we don't want to get the sensitive technology can get it from a variety of sources. If it's only the U.S. that says we're not sending it there, then the folks we don't want to get it can still get it. They get it from somewhere else, and all we've done is hurt U.S. industry. And so that was apparent, with that multilateral coordination being key when it comes to the Russia controls after the invasion of Ukraine. 38 countries came together and put in parallel and complementary controls. I'm on the enforcement side, though, and my concern, and we've been working hard on this, is over time, it's great that there are 38 parallel controls on paper, but if they're not enforced in a parallel way, that sort of level playing field is going to get unlevel. And there isn't currently, I found out, an existing sort of multilateral enforcement coordination mechanism or body, like a way to sort of all talk to each other about enforcement on export controls. And so we're trying to build one. That's hard. It's taking a lot of work. We're pushing in a bunch of different areas. We're working through the EU and the Trade and Technology Council to try and build out an enforcement coordination mechanism there. We're doing it through our Five Eyes partners. The G7 statement from the most recent meeting also announced the formation of an export coordination mechanism there for sanctions and export controls. And my view is, let's get them all. Let's push them all. If they all get stood up, great. We can see whether there's overlap and combine or whatever. But I'm not sure which one will get across the finish line first. So we're pushing in all ways to make sure that we're able to have that multilateral coordination that I think is so important. In the meantime, we've been doing a ton of bilateral coordination. So our country with other countries. This week, just to give you one example, there's a delegation from Malaysia that is back in DC. I met with them on Monday before coming down here. They are being trained by our folks on how to do administrative enforcement. Just like Andrea said, that can be a new thing for certain parts of the world, so we're spending a week together. And this isn't just the first time we interact with the Malaysians a lot and other ASEAN country delegations, as well as our European partners and the Five Eyes. So the last bilateral relationship thing I'll mention is for the first time ever, we have embedded one of our intelligence analysts in a country overseas. It's Canada. They're working with the CBSA, and we're working, that's allowing, just having like an analyst there embedded with them has allowed there to be so much joint effort, so much sharing of case information back and forth, of leads back and forth. It's really been a home run, and we're really excited about it, and maybe, down the road it can be a model to replicate elsewhere.
And one question I've always had is that, as we all know, the in-use checks in particular that go on with regard to exports are a huge tool in anti-circumvention efforts and things like that. Do you find a general, a greater level of cooperation or willingness to embrace some of those now, or is that really a case-by-case basis?
Yeah, I think so. So for folks who don't practice in this area, we have, in addition to our domestic footprint, we have some of our people are located outside the U.S. They work out of U.S. embassies, and they go to companies in the host countries to do inspections or checks, basically, to make sure that the item that supposedly got sent there is actually stayed there and didn't get diverted elsewhere, and that it's being used for the purpose that the exporter said it was being used for. And yeah, we get I think overall pretty good cooperation. We had been having some challenges getting our end use checks scheduled in China in particular, and so I changed our policy that if our end use checks, and this is true for any country, it's not China specific, have been pending for a certain period of time, that means we're not able to ascertain that the company that the thing got sent to is actually complying with our rules, so we're going to take action. I think it's 60 days, and then if no end-use check, we're going to start the interagency process to put them on our unverified list. And if another 60 days go by after the unverified list, we still haven't gotten a successful check, we're going to do the interagency process to put them on the entity list. And just putting that, again, to my point earlier, like sometimes to ensure compliance on the front end, there have to be some real consequences on the back end. That got their attention, and since then we've actually been able to knock out a bunch of the checks, and companies that had been on the unverified list, because we've been able to remove some of them, and then we're scheduling the others.
Mm-hmm. Thank you. We're now going to turn a little bit more with the time that we have left, because we do want to make sure we have time for questions, but we're going to turn now toward compliance. We heard a lot about compliance this morning and the heightened importance that the whole of government effort places on compliance, good compliance, not just compliance for show. And there is existing guidance out there, really from all of your agencies. But in particular, I want to ask Matt Axelrod and also Andrea, to expand a little bit on BIS's and OFAC's, compliance guidelines, in particular, the key elements that you're looking for.
Sure. So I can. You want me to start? Why don't you start?
Okay. All right. So I think we put out a few years ago a framework for compliance commitments, and we did so after thorough, collaboration and consultation with our interagency partners, BIS chief among them. And so I think that we want to make sure that when you are formulating a risk-based sanctions compliance approach, you are taking account of your your risk factors, your size, your geographic location, the counterparties you have in their location. And we wanted to replicate the same themes you hear across in talking with all other government agencies. And those are management commitment to sanctions compliance, making a risk assessment, making sure there are internal controls, making sure there's training and testing and auditing. So we didn't want to throw a curveball in. We want to make sure that everybody is looking at sanctions compliance much like you'd look at export control compliance. But we also, through our civil enforcement matters, where we can get into a little deeper, where we see issues, when we issue a civil enforcement kind of what we call a web post for a case we conclude, we often try to highlight the issues where things went wrong. So for example, at the end of last year, we brought an enforcement action against a multinational company called Danfoss. And what was happening there was that I believe there were subsidiaries of that company were actually processing transactions related to sanctioned jurisdictions like Iran, through third parties to conceal the Iranian identity through a foreign located branch of a U.S. financial institution, causing that U.S. financial institution to violate sanctions, essentially. So the Danfoss's lack of ability to control that, to see that, to appreciate that, to put in place controls to make sure that this was not happening was what motivated us to bring our enforcement action, but also to make sure that we explain the reasons why we brought it, why we thought it was significant, because we think that this is an opportunity to learn what we think is important when it comes to applying compliance controls when you're facing a sanctions issue.
Yes, what she said. I think for the general principles, I think Andrea covered it really well, so I won't rehash that. I'll just add a couple of things on top. One, on our website, we have a very detailed compliance guide, just like OFAC has one. We have one too, so you can read it there. It's over 50 pages. I won't attempt to distill it now. I will give a plug for our website, though. If you the overall BIS website needs to be redesigned. It will be redesigned. But the enforcement website, I actually think, is in pretty good shape. And if you want to know what we're up to and what our policy changes have been and what recent enforcement actions we've taken and what I'm saying when I do public speaking, it's all there. If you Google BIS enforcement, you can find our enforcement website. You can even sign up for enforcement alerts so that when we do a thing, it'll get pushed to your inbox and you don't have to keep pinging our website. I'll just say a couple, and so the compliance guidance is on there. I'll say three sort of quick things or tips. I think these are usually more tips for trade lawyers or industry, but for white collar lawyers are worth knowing too. First, I think because of the active period of time that we're in, we're putting folks on the entity list not infrequently. The controls are shifting with regards to Russia, not infrequently. There's a lot happening in this space, and what that means is you can't just vet customers at the beginning of a transaction, right? Or vet them once and then just keep selling to them month after month after month, because it may be different. So, right, all various stages of the transaction, it's important to, check again and run through the consolidated screening list and the other tools to make sure you're not running afoul of our rules, because either the rules may have changed or the parties, prohibited parties may have changed during the length of the transaction. Second, I said this before, but I'll say it again, get to know your local OEE agent rather than sort of memorizing all the sort of ins and outs. Having a local OEE agent who you can use as a resource, I think, is really important. And then the third thing I say that sometimes I think maybe trips folks up with our stuff from a compliance perspective. There are certain items where you're going to need a license to ship overseas, and you get the license, yes, you're allowed to ship. There are other things where you don't need a license, you can just ship. Separate from all of that, I think there's another level of analysis I'd encourage people to do from a compliance perspective, which is the reputational one, right? Like, even if this is technically legally allowed under our regs, like, is that the kind of thing your company wants to be shipping to that part of those, that other sort of recipient in that part of the world? Depending on what it is, you know, your clients will know their business is the best, but sometimes, you know, it may be technically on the right side of our regs, but from an overall compliance perspective, it may still be something that you want to think twice about.
Oh, that's great. I appreciate that, Matt. Matt Olson, question. What are the kinds of things that DOJ looks for in terms of corporate compliance when your prosecutors are in that decision-making cycle about whether or not to prosecute, and then how to approach it if they do?
Right. I mean, I think Andrea and Matt, your comments about the importance of having a strong compliance regime, absolutely critical, right? I mean, look, we're in the position of having to understand that companies, their legal teams, their compliance teams, their outside counsel are on the front lines of enforcement efforts. It's the case that you all, as representing these companies, as well as their in-house teams, they're going to have the best visibility into where there are compliance issues. They're going to be in the best position to make sure that who they interact with, who their customers are, who they have business relationships with, how those relationships are carried out. They're the ones that are going to be in a position to enforce enforce the laws, because they're going to be seeing those in the first instance. And look, I mean, criminal prosecution is and should be a tool of last resort. It's a critical tool. It's one that we take very seriously, but it shouldn't be, it's not going to be the one that scales in the way that having good compliance regimes have. And so we're looking at those same sets of issues. What type of compliance regimes do companies have? How seriously do their executives take those issues? And has there been early disclosure? Obviously, is one as well. I think the big point, the big takeaway for me from this conversation is, we've learned what a good compliance regime looks like and how that matters in making prosecution decisions from other contexts, particularly from the Foreign Corrupt Practices Act context. And you mentioned that earlier, Matt. We've learned about how that looks there. Now we're in a global situation where we are very concerned about sensitive technologies reaching our adversaries, tilting the balance of power, as those sensitive technologies can either aid those countries' military capacity or actually enable them to carry out human rights abuses. So we're going to take very seriously how those companies are setting up compliance regimes to comply with our sanctions and export control enforcement, as we look to apply that lens of compliance in this critical area where we're not talking about corrupt practices, but we are talking about something that's core to our country's future, and that's national security.
Okay, thanks, Matt. Steve, how about compliance from, it's tough to go forward after this, 'cause, a lot of your thunder has been stolen, but.
Compliance for HSI is called Project Shield America. It's our industry outreach program. Sorry, Matt, that's all I got. It's a partnership, it's outreach, it's training, it's really working with industry on just informing them of the new export laws, ITAR, sanctions, embargoes, asking for the partnership, sharing red flag indicators. And the reality is we do it a lot with the Department of Commerce, FBI. I will reiterate a little bit what Matt said. I'd say call HSI, but honestly call anyone. And then we offer to all of you out there an opportunity, if any of your clients or any of the folks that you know or represent, more than willing to do an outreach and provide a relationship across the U.S. government on all of us, or across all of us. And then, you all have heard this probably before, right? Our first encounter doesn't want to be where we're issuing a subpoena or executing a search warrant. And I think this is where, as a last resort, that we want to do, but we want to be proactive and establish a relationship with the industry.
Okay, great, thanks, Steve. Well, given the time that we have, we want to have a little bit of time for questions, but this brings us to a kind of our wrap-up question where we really want to ask each of you to prognosticate a little bit, maybe give us a little bit inside baseball if you want to. Probably don't want to, but if you do, we'll take it, and kind of look at where we're going over the next year in particular, what should we expect to see? We've talked about some initiatives I know that are fairly new, and so there's going to obviously be the evolution of those. But we'd just like to ask each of the panel members to wrap up with that kind of thought about the future. And we have no given order, so Matt Olson. John.
Sure. I mean, I think we've pretty much signaled. There's no secret. I think the big takeaway for me is one that we are following the threats that we face in our criminal prosecution and enforcement efforts, and we are looking at nation-state adversaries and what tools we can bring to bear to protect our national security, and that sanctions and export control are at the top of the list. That's one, and two, that we are focused on the intersection of corporate actions and corporate wrongdoing and national security. And so that's, those two things together, to me, are the big takeaways as I thought about this panel, and as I look ahead at the next year, and going out beyond the next year of where our enforcement priorities are going to be. And that's really, again, focused on how we can use our law enforcement authorities to protect national security.
Okay, great, thanks. Andrea, you want to?
I don't know that I can top that. I will focus in a little bit, just pivoting off, again, our Tri-Seal alert issued today. One specific area of focus for all of us is going to be sanctions evasion in the Russia space, and specifically third-party facilitators for the war effort.
Yeah, looking at the next year, I think that across the USG, we need to continue to educate and train and provide a cyber and financial enabled kind of investigative workforce, and I think that's where we're investing in. And then also continue to be proactive and looking at the vulnerabilities that I think U.S. companies will face with the CHIPS and Science Act, and I think we need to continue with the strike forces, the task forces, and the leadership from the top and all the way down to our workforce. So we're going to continue to push that.
No inside baseball, but I will give you a prediction. So I'll see you again next year, maybe a few years into the future, see if I got this right or wrong. But my prediction is this is not a flash in the pan, the stuff we're talking about, right? It's sort of come to public consciousness, I think, because of Russia's invasion of Ukraine and some of the stuff going on with China. But when that war ends, I think the importance of sanctions and export controls and the fact that the risk of getting that wrong is no longer some sort of technical regulatory risk, but is enterprise risk for your company. I think that's here to stay. I just think the way the world is changing and the advances in technology that we've been talking about mean that this area, because of its national security prominence in a way that wasn't true 5-10 years ago, is going to be an increasing and sustained area of focus for the Commerce Department, for Homeland Security, for OFAC, and for the Department of Justice.
Thanks, Matt. So, I take it then from the practitioner standpoint, from the outside company standpoint, the message is that export control, economic sanctions focus on the enforcement side is here to stay.
Yep.
It's not event-driven. It's not a reactionary kind of thing. It's something that companies should become part of. I believe the Deputy Attorney General said this morning that if these are areas that you once considered obscure, if they're not at the top of your list, they better be headed there.
Yep.
That's not exactly how she said it, but I think that was the gist of where it was going. So with that, we wanted to open this up for any questions that the audience has for our panel.
I have a question about how y'all view long-arm jurisdiction and looking at non-U.S. persons who may be trying to still do business with, we consider them block persons, but it's fine from wherever they are, from their perspective. And so obviously Lafarge was sort of, found a jurisdiction, got them, non-U.S. entity. But how do y'all determine when it becomes a target versus, hey, we're just going to kind of lean on them to encourage them not to do business with Russian state entities or whatever it is?
I'll take a stab at this. I think, so it's a balance because, for example, let's say you've got a country that is putting its interests ahead of what we would consider priorities and has business with Russia, And, at what extent, it's a problem for us, right? But what tool do we deploy to go against that problem? Do we talk to the country and say, listen, do you value your relationship with us, or do you value your relationship with Russia? Like, we see a choice to be made here. And I think you can rely on the fact that that's happening across the US government. When it comes into an issue of, say, we're going to deploy sanctions, a lot of that's going to be case by case. For example, if we see an entity in a country that's actually supporting the war effort, so for example, the Space City company a few months back that was exporting geolocation data to the Wagner Group for use in Ukraine from China, that became a sanctions target. So it's always case by case. There's always some level of, we'd rather have you with us enforcing against it rather than us take a sanctions action, but we will deploy a sanctions action if the facts merit.
I think you have one over there.
Hi, I'm Max Fillion. I'm a journalist with Global Investigations Review. This is kind of a two-parter that builds on that. I was wondering what countries or jurisdictions that you're seeing are most commonly used as transshipment points to evade sanctions and export controls. And secondly, what does your engagement with them look like?
Yeah, so I don't know if you've had a chance to see the Tri-Seal alert that we've been talking about yet, but I think there's a list of countries in there. It was also a list of countries in the Joint FinCEN alert I mentioned. I don't want to get them wrong off the top of my head, but some of them, and this is really dangerous, but some of them I think are, they're in there: Turkey, Armenia, UAE, China.
Yeah, I don't want to get it wrong either.
Yeah, there are others. Anyway, so there are others. There are others there as well. And in terms of engagement, yeah, that's been I know again, Commerce and Treasury working together. I'm sure DOJ and HSI are doing this too. But we've had sort of folks, leaders from the departments go to certain countries and deliver a message like, hey, this is happening through your country and we really need your help to make it stop. I know my co-assistant secretary from Commerce, Taya Kendler, was in Turkey recently, as was Undersecretary Nelson from Treasury, was in Turkey and I think UAE
and Oman.
And Oman. Yep. And so those trips are happening. It's as Andrea said, that third country and evasion and transshipment is a real focus area for us right now.
And I would just add, I think the lesson and the experience from our Task Force Klepto Capture after the invasion, that was one of the remarkable achievements of that team was, and this was with all of these agencies, the outreach to European countries and the sort of unified effort to impose sanctions on Russia. As you said earlier, Matt, this is a multilateral effort. So it's really we all have the same talking points when our leaders go, when we go to these countries and we talk about cooperation on intelligence sharing, on evidence, on legal tools that we can learn from. How do you do this? How do we do it? There's a really strong effort to cooperate with those countries to ensure a unified effort, because it really only works when we work together.
Okay, great. Well, we are up against the wall on time, but if there are any other questions, this is a rare opportunity, so we'll take another minute or two if there are others.
I have a question. Can you talk, Matt, a little bit about the ICT supply chain effort? It's been approved within BIS. Are your agents going to start enforcing that? Will you see some action in that respect?
Yeah. So Wendy's question is about something called ICTS, which, as I understand, is a effort to make sure that the sort of communications sort of software and supplies and equipment in the U.S. is sort of safe and secure. It's within my part of commerce. It's not within my part of commerce, if that makes sense. In other words, I work in the Bureau of Industry and Security. ICTS is being handled in the Bureau of Industry and Security. I do export enforcement. This is not that. So if the question is, will my agents have a role to play in ICTS enforcement. I think that's still something folks are working through, and sort of don't have any announcement today on that. But ICTS, I know there are a lot of, again, Matt made a pitch if folks want to go be prosecutors again, if anyone wants to work on these issues. I know they have to hire a lot of people to do it, and so spread the word. And that program is in the process of being built out. So, down the road on enforcement, I imagine we'd have a role to play, but we're not it's not developed to that state yet.
Thanks, Matt. All right, well, I think we've reached the end of our time. I want to first say a personal thanks to everyone on the panel. You're some of the busiest folks on the planet, and we appreciate all that you do to keep us safe, and really appreciate you being here. And I want to give a round of applause to our panel.
Everybody, thank you.